agree with me. They want me to have 200 jury trials the first week of March. I told someone yesterday, didn't I say we'll do one every 10 minutes for 2 weeks, right? Agree with me. Yeah, I mean, morning, everybody. It's Judge Nicola. We're on the record this morning.
Wow.
All right. Let's see what we got. Let's start with Larazo Camejo, case number 20 CT 124. Mr. Verderamo, I understand that the motion is not going to go forward this morning, that you and the state have reached a resolution. You want to set it on another pretrial. Is that right?
That's correct, Judge. Do we have a prosecutor?
We do. He's in the room with me.
Oh, okay. Yes, it's not going
For
forward.
whatever reason, Mr. Rabb didn't get the Zoom code this morning, so he's present.
Okay. Good morning.
He was the one who came in this morning and advised the court that the motion would actually not be going forward today.
Okay.
Oh,
I filed a notice of cancellation too. I'm sorry I didn't make it to your desk.
well, it may have made it into the court file, and no, I didn't see it. But that's okay, no problem. Let's just see where we can schedule this.
Well, we're set for a pretrial on Wednesday, so
This coming Wednesday?
I think so.
As in tomorrow?
Yes.
It took me a minute. I just had like a brain jog a little bit here.
Yes, Wednesday. Yes, the 6th.
Tomorrow.
So we're all set.
Do we want to move it past Wednesday? Because it sounds like this is probably going to be a plea in absentia. Is that right? He doesn't live here?
Correct.
Do we want to move it to my February pretrial?
We can do that.
And then if you want to schedule it for a plea in absentia, we can find a place to slot you before then.
No, just leave it. I have other cases. I can address it tomorrow, just so it's not confusing for everybody else.
Okay.
We'll just
It's
leave
up
it
to you.
tomorrow. We'll
I've
move it
got
up.
Tommy here, and Tommy can easily move it for me if that makes sense.
Doesn't matter. Whatever's easiest.
Let's move it. Because I think I have like 100 tomorrow, and this would be one less.
Okay, 99.
So 99, right? All right. So my February pretrial conference is February the 10th at 9 a.m.
Okay.
Right? That's what you got down, Tom? February 10th at 9 a.m.
Great. Thank you.
Thank you. See you then.
Thanks.
Oh, see you tomorrow, I suppose.
Yes. Actually, I have one more too, but
Oh, you have more this morning? Oh, you also have Mary Monk. And that's 2019 CT 1391. This is a motion for return of property.
yes, Judge. She was arrested on July 5th. I'm sorry.
Okay. Oh, I was just going to ask Mr. Rabb if there was any objection to the motion.
No objection, Your Honor. It looks like that.
Great. There's no objection to the motion. So, Mr. Verderamo, if you want to send me an order on it, it will be granted.
Okay. I believe it was sent already. If you don't have it, I'll send it again.
Okay, it may be that it just hasn't been printed yet. Did you email it to Jen?
On December 8th.
Oh, well, then she should have it.
We'll send
She
it.
didn't, yeah, I'll check with her first, and then if she needs it, I'll just have her get in touch with you. She
Right.
usually has everything kind of lined up by date, so it may have been that she just didn't grab the stack to hand me for this morning. So I'll check with her and then we'll let you know, okay?
Thank you. Have a good day.
Thank you, you too.
Bye.
Mr. Chandler, it looks like you have one matter before the court, which is a similar motion for return of property.
Yes,
Jose
ma'am.
Garcia, 20 MM 1903.
Yes, I have motion to return property, similar situation. My client was arrested in November. State filed a notice of no information. He, pursuant to the first appearance order, turned in firearms that he owned, and we're requesting that those be returned from the sheriff's office.
Any objection? No objection to that, Mr. Chandler. If you want to get me an order, I'll sign it.
I have an order prepared, and I will email it over. I could share screen now if Mr. Rob wanted to see it, or I could just
Well,
email it.
Mr. Rob is in the courtroom, so I don't know that he could actually see it, because otherwise he'd have to come up here, and I
Nope.
can't let him do that.
No problem. I will email it to Jen and Mr. Rob in the next 5 minutes.
That sounds good.
Okay, thank you.
All right, thank you. Have a good day.
You too.
Thank you. Mr. Casassa, who are you here for today?
Mark Joslin, Judge. Motion
okay.
to expunge.
Interestingly, it doesn't show you as counsel of record. I don't know why, but it's case number 1990 MM 928. Wow.
Well, Judge, I probably put somebody else's name because Mr. Rabb always objects to my stuff. Maybe he wouldn't object to someone else.
Oh, you wanted to surprise him this morning? Just
I did. I'm so surprised.
So there he is.
Mr. Casassa thought I wouldn't do my homework.
Oh, yeah.
Your Honor.
What are you saying?
He said you didn't think he'd do his homework. So
Oh.
that's why you surprised him. And he doesn't have any objection actually to the motion.
Judge, is he feeling okay? Because he's not objecting to anything. I think something must be wrong with him. Maybe we need to take his temperature.
He doesn't, he
That's
doesn't.
fine to me, Judge, Mr. Casassa, and just feel in a different spirit.
I'm sorry.
I was thinking that maybe we could joke about people not feeling well these days, but I have a feeling that that would get us all in trouble. Like if you even, like you can't even sneeze these days. If you sneeze,
But I will formally withdraw
drive
that joke.
people out in droves with one sneeze.
I will formally withdraw that joke.
Okay, thank you.
Judge, I will submit an order and obviously a check to the clerk.
Sounds good.
And
Thank you, Judge. Good day.
Wait, there's one more thing. Yes.
the record has reviewed the motion to certificate.
So he did do his homework. He wants you to know that he has reviewed the certificate, the affidavit, and the motion, all three, and agrees with you, Mr. Casassa. So you win. So you could do like one of these, like.
Happy New Year.
That was your Happy New Year gift. Oh my God. He is doing this kind of a dance right now. I shouldn't try to do that. It's terrible.
That went out of style a while ago.
I don't know. I have a teenager and I don't even know what she'd say if I tried to do that dance. So, but I did enjoy that. That was great. Oh, and by the way, it was live on YouTube too. So you've got that. I'm sure there's all kinds of people. You might actually get, like you might become, what do they call them? An influencer.
I might become a dance professional, Judge. Thank you very much.
Anything's possible. Thank
Good day,
you.
Judge.
See you later. Bye. All right, Mr. Gorman.
Hello, Your Honor. Thomas Gorman from Law Office of Donald Day. First case we have is Edwin Clark, 20 MM 656. This is defendant's second motion to allow the defendant to retrieve personal property. If I may, I have Mr. Clark present. If I can provide some testimony for the court.
Okay. And good morning, Mr. Clark. And Mr. Gorman, can you refresh the court's recollection? Why was it that I denied it the last time, that I wouldn't let him get his stuff? Was there a reason?
No, Judge, I think that was a different one. I think this one was, we had brought a motion in June, it was granted, but when Mr. Clark went and got his items with the police escort, he was only allowed to take what he could carry, and he was very rushed in that process, so only got a select items, and I'll provide a little bit more testimony, but this has not been denied. It was granted previously in June, and this is our second motion we're bringing now with a new basis.
Okay, but Mr. Gorman, I look at the motion here and it just appears to be a very general motion. Does he have a list of things by any chance that he wants to get? I mean, having a
Yeah.
list might actually make it go quicker because we could share the list and then say this is the
Yeah,
stuff. Can you
Judge,
get it?
that's why I had him here today to provide a little bit of insight to the court. But basically, he works outside. He's 84 years old, and he has very limited income. He has all of his warm clothing at the house still, as well as many of his tools that were needed. Specifically, the tools are his socket sets, his sockets, his wrenches, his mechanic type tools. He was not allowed to get any of those items last time around just because he could only take one load that he could carry. And this was back in June. Now, the more pressing issue is that he doesn't have any of his warm clothing. As I said, he's on very limited income, and so that's why we're bringing our motion. As I said, I can provide testimony from Mr. Clark with a little bit more information if needed, but that's our request, to allow him to go back one more time to get those items, so that we're trying. This is one of the ones we're trying to get to trial as quick as possible, Judge.
Of course. And just let me look at were they married or their boyfriend and girlfriend?
They've been married 20
Daughter,
years,
stepdaughter.
Judge, 28 years. They've owned that house for 16 years. As I said, Mr. Clark is 84 years old. That he's, all of his possessions were in that house, and he's kind of been making do since then, wanting us to get his case to trial as quick as possible. But we all understand that that's been impossible up to this point. So.
Of course. Well, and I've said it, and I'll reiterate it again. I'm happy to give you guys bench trials. I can't give you jury trials. So if you decided you wanted to go that route,
we understand, Judge, and I'll talk that over with Mr. Clark. I hadn't mentioned that to him.
Mr. Rabb, what's the state's position on this? I mean, I'm putting like back my family law hat back on when I used to be a divorce attorney and we had people who were married a long, long time. And I would say, why don't you get a list and we can get a list over to the wife and see if she agrees. And if she says, I agree with all of this, then that's super easy. You have the list. The list is attached to an order. Then the sheriff's department knows what's on the list. And then there's no problem.
Your Honor, the state has no objection to that. The state's only request would be that obviously the sheriff's office personnel.
Of course. Do you want to put a list on the record now, or do you want to sit with your client and just put one together so that it could be sent over to Mr. Rabb? And because for me, I have no problem with it. The difficulty is, as you said, they've lived in that house a long time. They're married, and we have to give her the opportunity to give some input on it. I personally can't see why she would want his tools of the trade. But then again, as you know, I also used to be a divorce attorney, and I would be surprised about the things that the people wanted just in order to get back at the other person. So
yeah, Judge, there's a lot more complicated stuff going on than I can go on the record with. Not the wife, but another interested party in the household that is, from our position, is the cause of much of this issues. But any event, I won't go into all that now. We'll save that for trial. The reason that we're requesting it in this manner to allow him to go back in, because he's not sure exactly where in the house some of these items are, Judge. And it's been a while since June. He would like to be able to try and furry out some of these items in the event that they've been moved around, etc. He is capable of getting a list together, but that was his intention because he was rushed so quickly last time he had the company of law enforcement. He could only take what he could carry. And Mr. Clark, he's next to me. He's a very slight man. As I said, he's 84 years old. He cannot carry a lot. And so that was why his request, he didn't want to have to be so rushed and to get these select items that he was interested in. But I agree, we're capable of putting a list together. I just figure for ease of all parties, it may be, if he can allow one more police escort in there, he'll be able to get those items and get them through until we can get to trial.
Does he have somebody that could assist him, that could help him not only pack the things up, but help him carry them and get it done? Because my guess is that with law enforcement, they're not going to want to give him lots and lots of time to go from room to room and drawer to drawer, and
No, I know.
They don't have the ability to do that.
Yeah, he does have a friend that's helped him with our assistance on the case, Judge. So I'm sure that friend will be glad to help out as well. But I can just tell the court, if we give a list, in my experience, here's what's going to happen. They're going to say we don't have any of that stuff, and we're going to be right back before the court. But I don't.
How do we-
I mean, maybe I'm just speaking from. That's what's happened a couple times. We've tried that, but.
My quandary with this is that I have to be able to give the victim in this case the ability to object. And if I don't have a list, and then I have him go to the house with law enforcement, the only way to be able to give her the opportunity to object would be for her to be there. And then, you know, he says, I would like this box of tools. Can I take it with me? And then all of a sudden we have a situation where you're not taking anything. Those are marital assets. And then I got my police officers in the middle. I have been through that so many times in the 25 years of being a practicing attorney. I even made the mistake one time of volunteering myself to go over and assist the parties. Boy, was that a mistake.
Yeah,
So-
yeah, no, Judge, and we agree, these are complicated issues. Here's what our request would be. We'll be happy to get a list together, Judge, but I would ask when the state communicates to the victim to communicate directly with the wife, because from our perspective, there's another party who's a granddaughter that moved into the household that has been much of the conflict arising that is part of this, but the wife is the owner of the house. Mr. Clark and his wife owned the house for 16 years. So we'd ask that these items, which belong to Mr. Clark and his wife as marital property, that be the communication the state has, and try to leave out this other party, which is going to throw a wrench in things. But that's our only request, Judge. We'll try it that way. And if we can't get it accomplished, we may be back. Or if we get to trial, if that things open up, that'll solve everything.
One question, is Danya Smith his wife, or is she, because it says stepfather, stepdaughter. It's listing the victim as Danya Smith, which
Yeah,
is.
that's his wife, Judge.
Oh, well then that's weird. Okay. Because it says in the police report, the defendant, Edwin Clark, and the victim, Danya Smith, are stepfather/stepdaughter. So that's a mistake. That's actually his wife.
Stepdaughter.
They're saying that Danya is their stepdaughter.
Dania.
Yeah.
Yeah, Dania. Dana is my wife. Dania is the stepdaughter.
Yeah, they're very similar names. Donna is the wife. Danya is the stepdaughter. So if it's-
Danya is the one the no contact order is with. When I look at the booking sheet, Mr. Gorman, it says that the alleged battery occurred between Mr. Clark and his stepdaughter.
yes.
So there is nothing that I can see to prevent him from talking to his wife and, you know, coordinating her providing the items to him. But in the event that he can't secure that, I believe that I still would be willing to sign an order that allowed him to go with law enforcement. I just would like you two attorneys to, you know, work together, because obviously I know that we have to have communication with the victim, but really she doesn't have a dog in this fight as far as the property. I mean, we want to make sure that she, you know, is contacted, but for her to object to him getting the property that he owns, either himself or with his wife, I just don't see how she really could, other than say, you know, I don't want him to come to the residence, and I'm overruling that.
And Your Honor, Mr. Stewart is the assigned prosecutor for this case. I guess my only question would be for Mr. Gorman, that stepdaughter who's the victim lives at the residence where this property is located.
That's what it says in the booking sheet.
Okay, and I will relay that to Mr. Stewart, and then Mr. Stewart contact Mr. Morgan, I imagine it goes for this.
Yes. So, Mr. Gorman,
Yes.
this is Mr. Stewart's case, and Attorney Rabb said he's going to convey the information to Mr. Stewart, but here's how I look at it. The no contact order is between your client and his stepdaughter, not his wife. So there's nothing that would prevent him from communicating with his wife and saying, would you mind getting this stuff together for me? This is what I would like to have. Although if you're worried that she's not gonna, that she's gonna destroy it, but even if you put the list together, she could destroy it. I mean, I hope
Yeah,
not.
Judge, as I said, there's a lot other issues here, but one of the impediments has been the stepdaughter has a tremendous amount of control over the wife, who's in very poor health, and any communication up to this point has been impossible because of the inability to even have access to talk with her. So
Yeah. How old's the stepdaughter?
the wife has had a stroke and some other health issues and a heart attack. It's our understanding, we've heard through the grapevine recently. So there's a lot of stuff going on here, but
Sure.
we'll try and sort it out through a list, Judge, and hopefully that can be accommodated. If not, we'll be back before the court.
Okay. Well, that makes sense. Yeah, is it your position that, is he and his wife, are they planning to stay together? Is that where we're at right now with this? At least for now?
He hasn't even been able to have any access to her because she stays in the house. She's homebound, and he's trespassed from his own house because the daughter has moved in. And so it's a complicated situation, Judge, that
Yes.
these are all issues that we'll raise in trial. But my point is, that's where, if the state talks to the stepdaughter's going to say, I suspect, I can't speak for what she'll say, but I can tell you from our impression from the parties that have tried to act as intermediaries that no to everything. But, we'll see. We'll try and sort that out, Judge. And if we can't, we'll be back before the court.
Okay. Well, the good news is that I have the ability to override her. Was it the fact that this was actually his wife and not his stepdaughter? I think it would be different. But the items that he's asking for have nothing to do with Danya Smith. They have to do with him and his wife and the house that they shared their entire marriage. So, as I said, I am going to ask for a list and that the list be shared with Ms. Smith. But it is the court's position that Ms. Smith does not have grounds to object to him getting his stuff because none of the stuff is hers. He can't take any of her stuff, obviously, but the stuff that he had either himself or with his wife has nothing to do with Danya Smith. So I am going to grant the motion, but I'm going to ask that a list is provided and a reasonable means of obtaining it with law enforcement is provided. Mr. Rabb, you're going to convey to Mr. Stewart, of course, the request, and we'll make it happen. As I said before too, I wish I could start getting these cases resolved and setting them on my trial docket, but my backup date is February 24th. I may have that week, and I definitely have the week of March 1st, so long as the plan to open up the courthouse, continues. And again, if you want to discuss with this gentleman whether or not he would like to do a bench trial, I could accommodate that a lot quicker. I could set those in probably in February.
And we'll talk with I hadn't talked with him about that, Judge, but we will talk with him about that. That may be the solution. So,
Okay.
but all right, Judge, we'll get with the state and then we'll go from there on Mr. Clark. And if we can reach a resolution that's acceptable, we will. If not, we'll be back before the court.
Okay. If you can't reach a reasonable resolution soon on this, if there's a big fight about it, please let Jen know, and I will let Jen know that I will expedite this. I'd like to have this resolved sooner rather than later. It's cold outside, and this gentleman needs to work. And the excuse of I just don't feel like it is not going to work with me. He should be able to have his stuff, especially since he's the one who can't live in the house. So I think that seems reasonable. All right.
Thank you, Judge.
Thank you.
I do have two other cases that
Oh,
are
yes, you do. Yes,
matters.
sir.
One is Yenelis Raga, motion to expunge.
Yes.
And this
19 MM,
Raga's
63.
case. One second, Judge, let me get the case number. Yes, Judge,
19
19
MM 1683.
Judge, we paid the $42. She's otherwise eligible. We'd ask that the court grant the motion.
Any objection?
Okay.
No objections granted.
And then the similar situation, Usdell Carrillo. This is case number,
19 MM 1682.
that's correct, Judge. The fee to the clerk has been paid. They are eligible. We're asked the court to grant the motion.
Any objection? No objection. Granted.
All right, thank you, Judge. Have a good day.
Hey, you too, Mr. Clark. Thank you. All right, Miss Wilson, you ready? We have Yana St. John, case number 20 CT 1824.
Good morning, Judge Nicole. It's actually Andrew McGann for Miss
I was
Wilson.
gonna say,
Yeah,
hey, you look a lot different today, Miss Wilson.
right. So this was a plea and abstention document that was filed
Yes, sir. Let me just
for
look
DUI
at it.
first offense.
Yes, sir, Mr. McGann. And there, you do understand, Mr. McGann, that this would actually be an adjudication. There's a reference in paragraph 14 that the state's offer might be a withheld adjudication, but of course we can't do that in a DUI.
Yes, ma'am, and Miss St. John is aware of that.
Okay. All right. So it looks like it's 12 months probation, may terminate early on 6 months, 6 months license suspension, $750 fine, DUI school, substance abuse evaluation and follow recommendations, random testing, no alcohol provisions, the 10-day vehicle impound, the 50 hours of community service, the victim impact panel, and the court costs and the cost of prosecution. Is that right?
That's what the offer that we had conveyed, correct?
Mr. Rabb?
Yes, Your Honor, the state has no objection. For the record, the state would that due to the extension. I do understand that Mr. Lee is aware that it is engaging in accurate judgment. The laws are showing.
Yes. I'll take the representations of Mr. McGann as being sufficient. Just let me take a look real quick at one thing. Okay. And Mr. McGann, you stipulate to a factual basis and venue for the purpose of the plea in absentia?
Yes, Your Honor.
Okay, and I've looked at it and I do agree that there is a factual basis and venue. Let me pull the plea back up.
I also let Miss St. John know to contact the probation department if the court accepts the plea, so she can get that set up.
Okay, good. And where does she live?
She lives in Naples, North
Oh, okay.
Naples, Vanderbilt Beach Road.
Okay, I was thinking maybe she didn't live here. Just want to make sure. Okay, there's the fingerprints. I was just looking to make sure we had fingerprints. We do. Everything appears to be signed. Okay. All right, so the court will accept the plea in absentia to the charge of DUI. The court will adjudicate her guilty, impose the court costs and the cost of prosecution. 12 months supervised probation may terminate early at 6 months and upon the successful completion of all terms and conditions. 6-month driver's license revocation, may obtain a business purposes permit. Did I say $750 fine? $750 fine. DUI school appropriate phase. Substance abuse evaluation, follow all recommendations. Random urinalysis or breathalyzer upon request and at her own expense. No alcohol during the terms of probation. No alcohol in the residence. No entering any bars, taverns, pubs, lounges, package stores, or places where alcohol is primarily served or sold. 10-day vehicle impound, 50 hours of community service, the victim impact panel, and all court costs and cost of prosecution. Although I think I already said that. All right, and let me just get this here. So, Mr. McGann, are you working up there in Fort Myers now? Or are you?
Yeah, I took over for Miss Wilson, so they're trying to substitute all those notices of appearance and all that stuff. So.
Okay. Because I've started to see you a little bit more on her cases. So.
Yeah, she left last week. She got a new job in Cape Coral area.
Oh, okay. All right. Let's see here. Yep, looks good. Thanks, Tommy. All right, well, congrats on your new job. I'm sure I'll be seeing more of you.
Oh yeah, always.
All right, thank you.
Take care.
Right.
Thank you.
Hey, you too.